Okay. Laskim Korla, I move that the Childcare Amendment Bill be now read the second time. I'm pleased to have the opportunity to speak on this important bill at second stage. The bill provides for the reform of Guardium ad litem arrangements under the Section 26 of the Childcare Act 1991. A GAL is an experienced professional who is appointed by the court to ascertain and to communicate the wishes and the best interests of a child who is at the center of childcare proceedings. The publication of this legislation is delivering on commitments in both the Program for Government and in Better Outcomes, Brighter Futures, the National Policy Framework for Children and Young People. The bill gives me the statutory basis to put in place a high-quality and sustainable Guardium ad litem national service within my department. It's the most robust way to ensure that the best interests of children and young people in childcare proceedings are met and that they have the opportunity to have their voice heard. This bill introduces a presumption in favor of the appointment of a GAL in all childcare proceedings before the district court. It also makes appointment of a GAL mandatory in all proceedings under Section 25 of the Mental Health Act 2001 and in special care proceedings. The Children's Referendum of 2012 saw the passing of the 31st Amendment of the Constitution, recognizing that all children have rights and pledging to protect those rights by law. With the introduction of this bill, I aim to ensure that our legislation better reflects and vindicates these rights. The 31st Amendment further provides that in the resolution of all proceedings involving children, the best interests of the child must be of paramount consideration. Under Article 42A.4.2, the views of the child must be ascertained. They must be given due weight, of course having regard to the age and maturity of the child. The bill introduces a requirement on the court to state how it intends to hear the views of the child if it declines to appoint a GAL. To date, the appointment of GALs has been ad hoc and largely unregulated. This bill aims to change that. This legislation underpins the introduction of a new GAL national service which will provide a high quality and sustainable service to children in childcare proceedings. This reform has been welcomed by children's rights campaigners and is in line with Joint Oireachtas Committee recommendations and submissions that have been received by my department. Section 26 of the 1991 Childcare Act provides for the appointment of a GAL in care proceedings where a child is not party to those proceedings and where the court is satisfied that it is necessary in the best interests of the child and in the interests of justice to have a GAL appointed. Currently, if a child is made a party to proceedings, they cannot also have the benefit of having a GAL appointed to them. But this bill allows the court to appoint a GAL to a child who has been made a party. The 1991 Act currently does not set out the criteria for GAL appointments, the qualifications required to act as a GAL, nor the role, function, and status of a GAL in care proceedings. But this bill, together with planned regulations, will provide clarity and will put in place a structured system of appointment. The 2015 Comptroller and Auditor General report noted a lack of transparency surrounding the selection, registration, and the vetting of GALs, as well as lack of oversight regarding costs. It noted that the rate paid in Ireland appears to compare unfavorably to the contracted hourly rate of GALs in other common law jurisdictions, while further noting that although GALs in this country are currently paid a standard rate per hour, they do not necessarily deliver a standard service. The CNAG report also recommended that my department examine options for engagement of legal representatives, as the current setup means that despite the large sums involved, there is no open competitive tendering process in place for legal representation for GALs. This bill is the culmination of significant consultation with relevant stakeholders during its development, and I want to acknowledge all the valuable contributions that my department has received. They have helped to ensure that the bill is fit for purpose and will improve the current system. The department held a public consultation at the end of 2015 on key areas of reform, and in total, 26 responses were received from children's rights and advocacy groups, GALs, legal practitioners, the judiciary, the Office of the Ombudsman for Children, TUSLA, and other state agencies. And many of their recommendations, together with those of the Joint Oireachtas Committee on Children and Youth Affairs, have been reflected in the bill. The general scheme of this bill was examined by the Joint Oireachtas Committee as part of pre-legislative scrutiny process in 2017. The committee made a number of recommendations, but two of the strongest recommendations were, firstly, that the GAL service should not be the subject to a procurement process, but should instead be set up under a statutory body. And secondly, that TUSLA, the Child and Family Agency, should not be involved in the provision of a GAL service. In 2017, I sought and received approval from government to establish a new national GAL service within an executive office of my department. This office will be created on an interim basis with a view to longer-term arrangements for the office being dealt with in the context of the proposed transition to a family courts system. TUSLA will have no role in the GAL office. The relevant expenditure will be moved from TUSLA to the department. I think that this approach addresses the Joint Committee's two strongest recommendations, and it is designed to deliver an effective and a quality assured and standardized frontline service for children in child care proceedings. My department will continue to work collaboratively with stakeholders in the further development of the preparatory work required to set up this new executive office. So, an overview of the bill: it provides for a new national and structured process for the appointments of GALs to childcare cases. While the appointment of a GAL will continue to be a judicial function, the GAL office will now be responsible for assigning a named GAL to a specific case. It specifies the role and status of a GAL and lists the factors that the GAL will have regard to in determining what is the best interest of the child. And this, of course, includes factors such as the child's age, maturity, and his or her views. In addition to providing for a presumption in favor of appointment of a GAL in all child care proceedings before the district court, a new provision is included in this bill requiring the court to say how it intends to hear the views of the child if it declines to appoint a GAL. A provision is also made for the mandatory appointment of a GAL in all proceedings under Section 25 of the Mental Health Act 2001. This section governs the involuntary admission of a child who has a mental disorder to an approved center. There's also provision made for the mandatory appointment of a GAL in special care proceedings. So under this bill, GALs will be able to apply to the court to procure as well a report on a child where no report exists, or when such a report already exists but is no longer relevant or is out of date. The bill provides that the minister may make regulations on the qualifications and the experience required to act as a GAL. The bill provides for a system of authorization of GALs and contains provisions to allow for the immediate revocation of authorizations in certain serious circumstances, such as a serious breach of regulations or a failure to notify the minister of a criminal record. Provision is made for a transition period in the first year of operation of the executive office. And this bill also presents an opportunity to implement a recent government decision to increase TUSLA's board membership from 9 to 11 members. In parallel with finalizing the legal infrastructure through this bill, my department is working to establish the new service and to have it operationalized at the earliest possible date following enactment of this legislation. My department is committed to working with experts and stakeholders to ensure that the new GAL service is fit for purpose and it is enabled to provide the best service to children in child care proceedings. We're engaging with a number of key stakeholders and experts to ensure that the best possible service is established under this bill. So I want to now turn to the provisions of the bill. In Part 1 of the bill, Sections 1 to 3 inclusive, they provide for the short title, collective citation, construction, commencement, and definitions used in the bill, as well as for the repeal of certain provisions of the Childcare Act 1991 and the Childcare Amendment Act 2011. These repealed provisions will be replaced by the provisions of this bill. In Part 2 of the bill, we insert new sections into the Childcare Act 1991 to provide for the reformed GAL arrangements. Section 4 amends the 1991 Act by substituting a new Section 24 for the existing section. And the purpose of this amendment is to reflect the intent of Article 42A of the Constitution, by confirming that in any childcare proceedings under the 1991 Act, the court must regard the best interests of the child as the paramount consideration. Section 5 inserts a new Section 24A into the Principal Act, and this new section provides that where a child is capable of forming their own views in any proceedings under the 1991 Act, the court must determine how to facilitate the child in expressing those views. The court will be required to give any views that the child wishes to express due weight, having regard to the child's age and maturity. Section 6 inserts a new Part 5A, titled Guardian ad litem, into the 1991 Act, and it will create new sections 35A to 35Q in the Principal Act. Section 35A sets out the definitions used in this part of the Act. Section 35B specifies that a person cannot be appointed as a GAL for a child unless the court has made an order directing an appointment under this section. And it also provides that the High Court must appoint a GAL for all children who are the subject of special care proceedings, and it creates a presumption in favor of appointment in proceedings before the district court. Once the High Court or the District Court has made an order directing the appointment of a GAL, then the Minister for Children and Youth Affairs under Section 35C will be required to appoint a GAL. Section 35D deals with the provision of legal advice and legal representation for GALs. It requires the Minister to provide legal advice and legal representation to GALs appointed in all special care proceedings. In proceedings before the District Court under Part 4, Part 4B, or 6 of the 1991 Act, the provision of legal advice or legal representation, or both, to a GAL will be at the discretion of the Minister. The bill sets out a list of factors for the Minister to consider when deciding whether or not to arrange for the provision of legal advice, legal representation, or both to a GAL. Section 35E sets out the core functions of a GAL. These are to ascertain the views of the child, where the child is capable of forming their own views, and having considered these views, to make recommendations to the court on what is in the best interests of the child. And in performing these functions, the GAL is required to regard the best interests of the child again as the paramount consideration. GALs will be required to prepare a report for the court, which conveys both the views of the child and the guardian's recommendations on what is in the best interests of the child. The GAL must also inform the court of any additional matters which are relevant to the best interests of the child and which come to his or her attention during the course of his or her performance of duties as a GAL. Having regard to the child's age and maturity, the GAL will also be required to inform the child of the recommendations contained in his or her report, the outcome of the proceedings, and any other matters relevant to the proceedings which the GAL considers appropriate. As regards the status of a GAL, the bill qualifies or clarifies that a GAL can be called as a witness by the court or by any party to the proceedings. The guardian's report to the court may also be received as evidence in the proceedings. The bill further clarifies that the GAL is independent in the performance of his or her functions and that he or she is not a party to the proceedings. Section 35 sets out the powers of a GAL and provides that a GAL is permitted to apply to the court to request that a report be obtained on any question affecting the welfare of the child. And a GAL may make an application where there is no existing report or where there is a report but the information contained within the report is out of date. Before making an application to the court, the GAL is required to consult with the parties to the proceedings or the counsel or solicitor, if any, representing the parties. And this section provides that a GAL may also make an application to the court in relation to the provision of information from any person on any matter which relates to the GAL's functions. Section 35G allows the GAL to make a request to TUSLA for information in relation to the welfare of the child, which is necessary for the performance of his or her functions. And subject to the Data Protection Regulation and the Data Protection Act 2018, TUSLA is obliged to comply with such a request. And in the event that TUSLA refuses to comply with a request from a GAL for information, the agency is obliged to provide the GAL with the reasons for its refusal. TUSLA will not be required to furnish information which would be exempt from court proceedings on the grounds of legal professional privilege. Section 35H specifies the circumstances in which an order appointing a GAL to special care proceedings in the High Court or proceedings in the District Court ceases to have effect. Section 35I provides that the Minister for Children and Youth Affairs will pay any reasonable costs or expenses incurred by a GAL while exercising their functions under this bill on or after the relevant date. Section 35J provides that the Minister can develop and maintain a regulatory framework for the purpose of ensuring that GALs are held to high professional standards when performing their functions under this bill. And Section 35K provides that, subject to the Data Protection Regulation and the Data Protection Act 2018, the Minister may request that a GAL provides the Minister with information in relation to their functions. And this provision is included in order to allow for the appropriate management and supervision of GALs. Section 35L provides that the Minister may issue an authorization to those persons that he or she considers appropriate to perform the functions of a GAL. A person will not be considered as an appropriate person to perform the functions of a GAL unless they fulfill the requirements of regulations to be made under this section. And the regulations may prescribe matters such as the particular professions from which GALs may be authorized and the qualifications and minimum levels of professional experience required. Section 35M provides that a person who has been authorized to act as a GAL is required to notify the Minister in writing of any relevant matter which would affect their authorization. Section 35N provides that the Minister may revoke the authorization of a GAL in certain circumstances. And Section 35O sets out the circumstances in which a GAL's authorization will cease. To avoid disruption to ongoing proceedings, this section provides that where a GAL has been issued with an authorization for a fixed period and that authorization is due to expire, the Minister may extend that authorization until the conclusion of those proceedings. Section 35P provides that the Minister may enter into a contract for services with persons and issue such persons an authorization to perform the function of a GAL. Section 35Q sets out the transitional arrangements to be put in place to ensure that there is minimal disruption to existing GAL appointments in ongoing proceedings. Section 7 makes provision for a number of miscellaneous and technical amendments to the Principal Act, which are set out in detail in Part 1 of the schedule of the bill. And Section 8 provides for the amendment of those acts specified in Part 2 of the schedule, and these amendments to other acts are for the purposes of inserting references to this bill. In Part 3, Section 9 of the bill, it provides for an increase in membership of the Board of TUSLA by 2 ordinary members. A number of consequential amendments to sections dealing with a membership of the Board of TUSLA Act are also proposed. These consequential amendments provide for a pro rata adjustment in the number of board members required in various scenarios, acting as a direct result of the increase in membership. The purpose of reform in this area is to regulate and expand the provision of GAL services in a consistent manner across the country. The provisions of this bill will enhance the rights of children and the capacity of the courts to make the right decision in helping children and their families. And the bill will also help our legislation to better reflect the ideals of the 31st Amendment of the Constitution. And more importantly, it will put these ideals into practice in a very real manner in childcare proceedings. So under this bill, GAL provision will no longer be ad hoc and unregulated, but will instead be an organized service that will benefit children regardless of where they live in this country or where their case is heard. The bill also covers a crucial section of a much wider piece of legislation, the Childcare Act 1991, which is currently under review in its entirety by my department. And this reform also takes place against the backdrop of a much greater program of change, and that is the planned creation of specialized family courts. So I want to take this opportunity to commend the good work that many GALs have done and continue to do for children in this country, and I am grateful for their continued input into creating a better service. I would like to thank them and all the stakeholders who have contributed to the development of this bill. I'm pleased to have had the opportunity to outline the provisions of this bill, and I do look forward to hearing deputies' views on its contents, and I commend the bill to the House.